The Jacob Zuma parole court case, what has been a point of contention, of course, as expected, is the powers of the National Commissioner of Correctional Services. And the former Commissioner, Arthur Fraser, if you remember, granted the former president parole after he served just about 2 months of his 15-month jail term that was handed down by the Constitutional Court last year. This despite the Medical Parole Advisory Board not granting Zuma medical parole then. Advocate Dalim Bofu, arguing on behalf of the former president, has admitted that there's been a misrepresentation of what the board actually said. He said the board is advisory and there's a reason why it's called advisory. He also says the entire debate that has been centered around only one section of the Correctional Services Act, that's Section 79, is incorrect. He says this is because Fraser explained in his statements that his decision was actually based more on Section 75(7)(a) together with Section 79. Just for your interest, and myself, of course, when I looked through it, under Section 75, the Correctional Supervision and Parole Board is empowered, after considering the report on a prisoner submitted to it by the Case Management Committee, to place on parole any prisoner serving a determined sentence exceeding 12 months. Under Section 79, it says that any person serving a sentence in a prison and who, based on the written evidence of the medical practitioner treating that person, is diagnosed as being in the final phase of any terminal disease that is irreversible and that the applicant must be physically incapacitated. Now, you remember Dr. Mafa was one of the people treating Zuma, and he, according to the lawyers for correctional services, is the one who made the application on behalf of the former president. Earlier today, Advocate Mpatlela for the former commissioner argued that although the parole was found unlawful after a DA-sponsored application to the High Court, there should be allowance to reapply with the same documents. The former president could find himself heading back to prison if the ruling doesn't go in his favor. I tried to just summarize that for you. It's been about 4 hours. Now let's speak to Tyrone Maseko. He is a legal expert, just about what he thinks in terms of what's happened so far in court. Mr. Maseko, thank you very much for your time here on eNCA. Let's start with the argument around Section 75 and Section 79, with the Advocate Dalim Bofu telling the court that it's been quite unfair that the debate has been based solely on Section 79 when actually the former commissioner made it clear that he's basing it on 75. But of course, this is only about jurisdiction, as one of the justices says. It doesn't necessarily say he had the power to give the president parole. What do you think?
Yeah, hi, Maseko. Good afternoon. And I think the problem that Advocate Mbofu has is that the facts don't support this belated argument that he makes, because it seems from the arguments that have been advanced that on the record, on the basis of the record of decision, the decision was actually made on the basis of Section 79. And so I think it was a case of, well, Section 79 is a bit inconvenient for us because we're not going to be able to get over this hurdle of an advisory board that is now given an adverse decision to the one that was ultimately made by Fraser. And so because they cannot find a justification around that, I mean, they really, really struggle. Because as you've seen, the arguments have centered around the question of whether Jacob Zuma was at the final stages of a terminal illness. So they were unable and still not able to find a way around those jurisdictional requirements of Section 79. But I'm not convinced that jurisdictionally, well, substantively, the decision was made on the basis of Section 75. It appears to me, I've not read the record, but it appears to me from the decision of the High Court that the decision was in fact actually made following the recommendation of the Medical Advisory Board, Parole Board.
Now, we remember that the Medical Advisory Parole Board had actually said that they haven't proven that the former president was physically incapacitated, etc., and that the illness is, terminal. But of course, then you have the Dr. Mafa from the state hospital, from one military, who said that he is in fact terminally ill. But just explain to me, I still don't see where in Section 79 does it give the power to the commissioner to go against what the Medical Parole Board said?
Spot on, Maseko, and that is really what arguments are centering around, because what the appellants want to argue is that, well, notwithstanding the decision of the medical report, sorry, the medical parole board, that is only advisory in nature. And so Dalimbofu seeks to go into an argument to try and define what interpretation should be preferred for a recommendation. He says, well, it's merely a recommendation. There's nothing to say that, that is effectively binding on him. And what the court had found previously, the court had found is that there is not discretion on the commissioner. After the medical report board has made a decision and sent a recommendation, that there is, in the Act, there is no discretion conferred on the commissioner to then make a decision which is different to what the parole board has recommended. And so that's where we are right now. But I think they really are on a hiding to nothing on this question of discretion. There really does not seem to be a discretion. And the way I read it is that what they then seek to do now is say, well, okay, implicitly, even if that were the case, even if the court was to go against them in that regard, that actually the appropriate thing to do would have been to remit the decision back. So instead of the High Court imposing its own decision, it should have remitted the matter back to the commissioner, whoever the commissioner would have been then, because you remember that Arthur Fraser had subsequently been removed as the commissioner, that commissioner should then have had the opportunity to make to consider the facts and make a decision for or against granting parole.
And then there's also Advocate Mpahlela, who then also submitted to the court that they are hoping that the court will at least allow them to reapply using the very same documents that the justices have said are problematic, because the justices are unable to see, for instance, what exactly the former president is suffering from. There's nowhere, according to the justices, where the papers say it's a terminal illness that is irreversible, etc. So him still asking that the Supreme Court of Appeal allows them to go back to the High Court or to Correctional Services to reapply using these same documents, isn't that still going to be problematic?
Well, it is. And the court in this regard said, well, but why is there a need for that to be done, in this sense that the decision was made by, well, let's put it this way, the fact were advanced, whatever, all the reports were considered by the medical report board. It made a decision. What is not happening here, what we're not concerned with, is a review of the decision of the medical report parole board. We're not reviewing that decision. They made the decision on the basis on which they made. What is being looked at is a decision, is this question of a jurisdictional requirement that the commissioner ought to consider that that recommendation, and the failure by the commissioner to consider that decision. Now, we already know what the recommendation of the medical report board is. Thereafter, having found that there is no discretion on the commissioner, that has already been found by the court call. Whether the Supreme Court of Appeal will actually agree with the court call, we don't know. But if the Supreme Court of Appeal were to agree with the court call in this regard, to say, well, jurisdictionally, having those three elements under Section 79, and the first one, incidentally, is that the person who's being considered for parole ought to be at the terminal stages of an illness, and there is no recommendation, even if there was, Maseko, which is what they've gone through, even if there was one report from a doctor who says that, well, Jacob Zuma is the final phase of a terminal illness. But what holds the day, what carries the day here, is the decision of the board, the majority decision, and we know what the majority decision is in that regard. And so that is not under review here. So it is superfluous and frankly pointless to remit the matter back to the commissioner to make a decision, because the commissioner has no discretion, and that is why the court interposed a decision, it's effectively accepting the decision of the medical report board, because the commissioner does not have a discretion following the recommendation. And it's an odd one to keep referring to, I guess they cannot find a better word for recommendation, because I accept that, if you take a plain interpretation of recommendation, it does not suggest that something is actually binding. And there are no prefixes to say, well, in the Act, to say is it binding or not binding. It's just a question of what you understand as a recommendation.
Yeah, that's exactly where I was going to go. Speaking of binding or not binding, isn't it dangerous, this argument that Advocate Dalimpofu has now brought into the Supreme Court of Appeal, talking about there is a reason why this board has the word advisory in it. There's a reason why something would be recommendations, because then, the justices are questioning him around that, because it would seem that he's saying it doesn't necessarily mean that their decision is what the commissioner needs to go with. He can go above their decision.
Yeah. The problem there is that even if, does it really turn on the question of whether a recommendation necessarily means that what you are suggesting, as it were, is binding? Well, even if the court were to take a view that says, okay, fair enough, will not take a strict interpretation of the word recommendation. We'll work with it as a suggestion that we, the Medical Parole Board, are putting to the commissioner. The difficulty that Arthur Fraser faces is that he still has to pass the test of rationality. So he may pass the test of legality in the sense that the Act gives him discretion, but he's still got to apply his mind. And if you're going to go against a decision of a recommendation by experts, given that you're not a medical expert yourself as the commissioner, and the decision centers on a question of legal expertise and hence the requirement for the Medical Parole Board, then you have to give reason, and that's why I keep going to the record, as to why it is that you want to depart from the majority decision of experts in an area in which you're not an expert. And therein comes the question of irrationality, and that's why the court actually finds that his decision in this regard was an irrational, because he's not able to give reasons as to why he wants to deviate from the recommendation of the medical report, other than to rely on one other recommendation by a doctor, which is vague, quite frankly, as to whether or not it meets the test in the Act of final stages of a terminal illness. Nowhere does it say that it is actually Jacob Zuma suffers from a terminal illness. And so the decision would still be irrational in that regard and unreasonable, because you've gone against a recommendation from experts, but you have not given sound reasons as to why you want to go against that recommendation.
Tyrone, thank you very much for your time here on All Angles. I'm sure we're going to still be speaking about this case for quite a while. It was something, Section 79 was something that was brought up for the first time in South Africa after the release of Shabir Sheikh. And of course, it's now back in contention. Thank you very much for speaking to us, Tyrone Maseko. He is a criminal law expert, speaking to us there from T Maseko Attorneys, speaking to us there about the court case with President Jacob Zuma's parole and whether or not it was lawful. All right, now, here's some breaking news.